Are you gonna be on my side if I let you up?
Sure, Chick, sure. I'm on your side. Just let me up. I'll do anything you say.
Okay, Skipper. You're on my side.
Microsoft's conduct stifled innovation, eliminated competition, denied consumers choice, and this for the foreseeable future.
Look, if they bring a better product to the consumer and consumers like it and they're buying it because they like it better than what else is out there in the marketplace, Microsoft shouldn't be stopped from doing that. Everybody's better off.
It was the defining antitrust case of a generation, United States versus Microsoft. The case alleged that the giant software company based in Redmond, Washington, crippled competitors' abilities to bring product to market, instead of winning in the marketplace through innovation. On the surface, it was a struggle for dominance over the internet browser between rivals Microsoft and Netscape. But in fact, the stakes were much higher.
It took one of Bill Gates' assistants to go to Cornell University, and I think it was 95 or 6, and discover, my God, everyone is on this thing called the internet, and we're not. And this company, Netscape, is providing a browser that's a window to the internet, and we don't own it. And it could become an operating system to compete with Microsoft's operating system, and that's a menace.
The management of every business has a continuing problem to improve their product to stay ahead of competition, or else.
Beginning in the mid-1990s, Microsoft embarked in a deliberate campaign to eliminate Netscape and Sun Microsystems as competitive threats to the Windows operating system. And the scheme involved both going to distributors, such as internet service providers and PC manufacturers, and effectively preventing them from doing business with Netscape or with Sun for its Java platform, and putting Microsoft's version of the browser inextricably in the operating system so that the operating system used Microsoft's browser regardless of what the consumer actually wanted.
The government had staked out a position that what Microsoft had done had violated the law, and Microsoft defended it on the ground that what they were doing was innovation.
They have an absolutely intense focus on the competition, more so than any other company I have ever seen. That initially can be a really good thing because it drives a tremendous amount of feature innovation with the products at Microsoft, but it ultimately, at the business level, becomes something very poisonous. And at the executive level, it's not about whether or not we innovated our products and they became great. It becomes about whether or not that competitor is dead.
There are two ways for someone like Microsoft to compete. One is on the merits, innovation, lower prices, better products, or not competition on the merits, which is eliminate your competitor, block your competitor for getting access to resources they need, or blocking them from access to outlets that they need. And this is not competition on the merits. None of those acts benefit consumers.
Should the browser be the only browser that works in Windows? And more to the point, should the browser that Microsoft makes be so tightly woven into the operating system that any other browser that might well be in the operating system doesn't work as well? And that was what the case was really all about.
The case, which was seen as a test of antitrust law in the age of technology, was heard by Judge Thomas Penfield Jackson of the U.S. District Court in Washington, D.C.
I didn't see any reason why conventional antitrust analysis couldn't be used to approach the problems represented here. We're talking about markets, we're talking about consumers, we're talking about consumer choice, we're talking about the pricing of commodities.
Part of Microsoft's defense hinged on whether it could prove to the judge that its browser, Internet Explorer, was not a separate product competing with Netscape's, but merely an extension of its Windows operating system.
There was a lot of evidence. We had a trial that went on for 6 or 8 months. Ultimately, it was proven to me that they were indeed separable products.
In the end, Judge Jackson ruled that Microsoft had illegally maintained their monopoly and blocked competing internet browsers from reaching consumers. Microsoft engaged in a pattern of interference and intimidation, using its monopoly power in the operating system market to punish any computer maker that tried to install a rival browser. As a remedy, Judge Jackson recommended that Microsoft be broken into two separate companies, one for the operating system and the other for applications such as the browser.
The case made by the government convinced me that nothing less than a division of the company into two parts would resolve the problem of the anti-competitive effect of Microsoft's business activities.
Although Judge Jackson's remedy was not implemented, the ruling itself was upheld unanimously by a court of appeals. The ruling also paved the way for claims resulting in billions of dollars in private damages. But despite the findings of the courts, the federal government and some of the states that brought the suit decided to settle the case after the 2000 presidential election.
Today we are announcing a strong, historic settlement reached by the Department of Justice and the Microsoft Corporation that will put an end to Microsoft's unlawful conduct.
The final settlement, rendered by the Court of Appeals, left Microsoft intact while imposing various types of competitive restraints and requirements. While some thought the remedy was well-balanced, others were frustrated that it didn't go far enough.
At the end of the process, after the Court of Appeals decision, there was kind of a validation that, yes, the antitrust laws have a role to play. Yes, they indicate conduct that crosses the line versus that doesn't. But they're also sufficiently flexible to allow companies to compete and innovate and benefit consumers.
I think it's fair to say that the judgment has had very little, if any, effect on the marketplace. It has not spurred innovation. It has not spurred competition. It has not significantly changed the browser market or personal computing.
We do know that but for Microsoft's conduct, there would have been more innovation, better products, lower prices, because that's what naturally results from competition.
One of the central issues of the Microsoft case was to confirm the role of antitrust protection in allowing innovations to get to the market so that consumers can choose the products they prefer.